Your Honor, I offer these medical records into evidence. Objection! Sustained. What just happened? You want to learn what happened? Come join me. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial attorney practicing law here in the state of New York. What just happened is that the attorney was trying to get into evidence your medical records. And because he did not lay a foundation to show that the records are accurate and kept in the ordinary course of business, the attorney representing the defense objected and the judge agreed with the defense lawyer. And what that means is that you cannot get your medical records into evidence, and that is deadly. Why? Because in order to have you testify, have your experts and doctors who treated you testify, they have to have your records in evidence. And the way to do that is one of two ways. Traditionally, we would have to call in a witness from the doctor's office and whatever records we were trying to introduce into evidence, and have the medical records witness talk about the procedure for keeping and maintaining those particular medical records. So, for example, Ms. Jones, how long have you worked at Dr. Gold's office? Oh, 10 years. What do you do there? Oh, I'm the records keeper. Really? Tell us about that. Well, as soon as the doctor finishes writing his notes, we then take those notes, we then put them into the file, we then take the file and then put them back into the file cabinet. And did you do that in this case? Yes. And have I asked you to come here with the patient's original records? Yes. And have you brought all of the patient's records? Yes. And are these accurate and true records that the doctor wrote at the time that the treatment was rendered? Yes. Your Honor, I offer these records into evidence. Any objection? No. Very well. Now marked as plaintiff's won in evidence. Another way that we can get around that is by serving a subpoena, which is a piece of paper that basically orders the doctor's office to either submit the original records into evidence or to prepare a copy of the records and then a certification which says, I am the records keeper in Dr. Gold's office, and I certify that these are true and accurate photocopies of the original record. And attach the subpoena to that and send them directly into court. For the most part, when somebody does that, the court will allow the records to come in without an objection. Your Honor, at this time we offer a certified copy of the patient's records into evidence. Any objection? No. Very well. Mark this as plaintiff's won for in evidence. And that's how we get documents into evidence. Now, why do I tell you this? I tell you this because it's important for you to understand how the legal process works, especially certain aspects of trial. And if you have legal questions and you're considering bringing a possible case, what I encourage you to do is to pick up the phone and call me. This is what I do every single day, 516-487-8207, or by email at lawmed10@yahoo.com. I'm Gerry Oginski here in New York. Thanks for watching.